I'd like to welcome you to the first in a series of quick lectures regarding some basic business law information. Now, this primer is intended for students who are studying the subject of mortuary law at a respective American Board of Funeral Service Education accredited institution. It is not meant to be the all go-to lecture on these subjects. I'm only touching the tips of the iceberg. And it's meant to complement other courses that you will take, which will study these things much more in depth. If you have already taken courses, especially those of you who are returning to school, this is going to serve as a primer, giving you much of the necessary information that you need to know to maximize your learning in the mortuary law textbook, and also to prepare you for your future professional examination obligations. So let's get started. Before beginning a business, one needs to determine the type of business structure to maximize their efficiency, maximize their profits, and also to minimize their liability. We're going to be looking at the major types of business models only, and there's infinite variations, which we'll touch on the important ones, terms that are in your glossary, but we're not really going to tear those apart and go crazy. So a sole proprietorship. A sole proprietorship is a form of business that is owned and controlled by one person. It's the least formal type of business organization, has the fewest requirements for establishment, and it's also subject to less government regulation, which makes this pretty much ideal, right? Except for it also has the most amount of personal liability. The owner is the business. It also means it is the most short-lived because if something happens to you, the business ceases. So this is a situation, common fact pattern, where an assessor, person that's writing a test question, gives you a scenario and asks you, hey, what type of business is this? And it talks about an individual who starts a business, incorporates, has themselves as the sole shareholder, and then hires himself back as the only employee. Do we have a sole proprietorship? Well, the answer is no. We have a corporation. And that's commonly what people do because they do not want to get sued personally and lose everything they own personally. So watch out for questions that are mixing things up. And we're going to study corporations in a second. Partnerships. So a partnership exists when you have two or more persons who come together as co-owners in a business. Now, typically these last longer than sole proprietors because you have two individuals. Now, you can have a dissolution of the partnership, and this can happen in various ways. And the most common is partner dies. So if the partner dies and doesn't leave heirs, doesn't transfer the ownership to anyone else, then essentially the partnership terminates. It reverts to a sole proprietorship, and then it stays on as a sole proprietor. Remember, do not fall into the corporation trap, where we have a corporation that's created and two people become the 50% stockholders, and away we go. Watch out for the corporation type of questions. You technically also have a dissolution between partners when a partner takes their share and sells it to someone else. The original partnership is extinguished and a new partnership is formed. So it's still a dissolution. So how can these things be created? It's got a bit more oomph than the sole proprietor, doesn't it? Well, it can be created by an oral or written agreement. Hey, do you want to go into business? Why don't you bring your lawnmower, bring my weed whacker, and we can go knocking on doors and start cutting lawns and trimming edges. You just created an oral partnership. You could put that in writing. Formal or informal. Okay, formal or informal, or even simply by conduct. And as you can imagine, when a partnership is implied by conduct, things can get a little sketchy in the courtroom. We're going to look at several major subcategories of partnership. So a general partnership. The owners all carry on business for the joint benefit and profit of all partners. Every partner is an agent, has equal management authority, and responsible for the debts and liabilities caused by everybody else, also known as unlimited liability. So in a general partnership, if your general partner parks the hearse into the back of an Escalade SUV filled with school kids, and he was on company business when he did it, that person has the option of suing any of the general partners because of the liability of all the partners for the business. A limited partnership is formed by two or more persons and having as members one or more general partners and one or more limited partners. Now, general partners manage the business, are personally liable for its debts and obligations, while limited partners invest money or invest property and basically give up, quote unquote, a little bit of the day-to-day. They contribute something. That something is usually considerable, and that is the limit to their liability. The financial investment that they have given the business, the $10,000 for instance, that is the limit of their liability. This is very important because when you're looking at questioning who's a general and who's a limited partner, is you might have to look at the duties. Did this person just donate something in the way they went? Chances are pretty good that's going to be a limited partner. Now, in the real world, you might have a person that donates $5,000 towards your cause. You need $75,000. And they say for $5,000, they want to be able to manage the day-to-day business and all sorts of other stuff. Well, what they're trying to do is that they're trying to be a general partner with the liability of a limited partner. That's not the way it works. If they are aggressively trying to be involved in the business and making your life miserable, chances are it's not worth the $5,000. And there's the slide that proves that. If they want to get more involved in the business, they generally change their status. Good or for bad. A limited liability partnership, okay, is a general partnership in which the partners as a whole, not the individual partners themselves, are liable for the tort liabilities of the partnership. In some states, liability extends to contractual relationships. And we're going to study a little bit of contracts, a little bit about torts as we go through the different lectures. And this is created by filling out proper forms, filing fee to the appropriate state office. So now this has a little bit more regulation than a regular partnership. Nominal or ostensible partners are partners in name only, usually appear in some way in connection with the business in order to make it appear they are partners, but have no real interest in the partnership. So this would be the individual who maybe is a local celebrity. Okay, local celebrity who also has a funeral director's license. And you make them an ostensible partner in your firm so you can have their name associated, but they really don't do anything. You know, if they're not going to drive the hearse, they're not going to be meeting with families or anything. They're just kind of there as a show of support, maybe as a marketing tool. And silent partners, the ones who may be known to the public as partners, but take no active part in the business. So what would be the big difference between a nominal and a silent? Well, the silent would be your same individual, okay, same individual, and does absolutely nothing for you. You can see that an ostensible partner appear in some way with the business, you know, show up, take pictures in front of it, and away they go. But for the most part, they're very similar. Look at that fine line between the two. Dormant partners are not known to the public as partners and take no active part in the business. So you would hire that local celebrity. They are a funeral director. You don't advertise them. You don't do anything with them. Realistically, they come in and they do absolutely nothing. Why you would want one of these probably would defy my imagination. You know, you're better off just buying them a beer and asking them their opinion. Secret partners take an active part in the business but are not known to the public as partners. So back to that same celebrity, come in, they embalm on the weekends for you. Nobody knows they have a funeral director's license and don't want anyone to know that they are a licensed funeral director. That would be a partner who does that sort of thing for you. Oh, corporations. Corporations. And in the funeral world, I hear time and time again, the corporations are the devil. So fact of the matter is, you can love them, you can hate them, but corporations are here to stay, and they offer some pretty good perks. Corporations are legal entities created under a state law with the power to conduct its affairs as though it were a person. Basically, a corporation is a fictitious person. Okay? It exists like an individual on paper. Corporations are the longest lived of the business models. They come into existence when the government of a state issues a certificate of incorporation or approves articles of incorporation or a charter for the corporation. When a corporation is established in strict compliance with the law, it is called a de jure corporation. A de facto corporation results when there is a defect in its establishment and exists in fact, not by right. And it must be recognized as a valid corporation unless set aside by the state. So, Professor Finn, what's going on with that? Well, very simple. You turn in all the paperwork, everything goes right, you have a de jure corporation. Everything went through, everything's done. So what happens if you have put everything in and someone loses something in the process? Or the background check on one of your corporate officers comes back with a hit and the state kind of slows things down. But now you've opened for business. Everything's kind of, the gears are turning. There's no way to stop it. You now have a de facto corporation. Okay? The state can recognize it as a valid corporation while you remedy errors, for instance. This is for the purposes of an example. Some of you may have better reasoning, better examples than I do. But realistically, the state can also at some point say, no, need to fix it, no good. Okay, that would be the difference. And corporations can be for-profit or not-for-profit. A domestic corporation is organized in the state in which it is operating, and a foreign corporation is organized in a state other than which it is operating. So, well, Professor Finn, what about, organizing overseas? Again, you would then have a foreign corporation. It's organizing in a state or country other than where it is operating. And people may do that for tax purposes reasons or labor reasons. It is what it is. A corporation is owned by its stockholders. Some definitions say shareholders. However, stockholders are not personally responsible for the debts and liabilities of the corporation and can only lose their investment in the company shares if the corporation goes belly up, if it goes bankrupt. So remember what we talked about. A corporation is a fictitious individual. If it was created on paper, you gave money to this fictitious individual. If that person loses it, that's all on that person. That is the benefit of the corporation. So corporations are owned by stockholders, and shares of a corporation are called stocks. Shares of stock can be sold or given away. One of the biggest things that we have is our stock market system, and some of you may have investments in the stock market and follow things regularly. Some people have made some great money on stocks. Okay. Generally, this is open season for stocks unless it's a closed corporation. Corporation may have rules on the transfer of shares, and that's called a close or a closed corporation. Stockholders in a closed corporation must first offer to sell their stock to the stockholders of the corporation before anybody else. They're trying to keep the ownership private. So the first people who have dibs are the ones within. If they don't want to pay the price or whatever the other rules you have to obey, it can go to others. Each stockholder is issued a stock certificate, which demonstrates ownership of the stock in the corporation. They're not going to send you 1,500 pieces of paper for 1,500 stocks. They'll send you a certificate, and that tells you how many you have. Common stock generally gives the owner a right to vote, a right to receive profits or dividends. They may also receive compensation if the corporation is dissolved. Notice the word may. Preferred stock is stock of a slightly higher quality. Okay, superior right to dividends in the capital when the corporation is dissolved. However, preferred stockholders may not have voting rights. Make sure you look at your information if you have stock portfolios to determine, one, what type of stock you have and what your rights are under those stocks. Corporations are usually governed by a board of directors who are elected by shareholders at an annual meeting. These individuals have legal responsibility to manage the corporation in the best interests of the shareholders. Disadvantage of corporation is the double taxation. Income of the corporation is taxed directly by the federal government, and because other people earn dividends, they are taxed again, which makes things a little grumpy for corporations, which is why they're always digging for tax loopholes and whatnot. Double taxation is associated with a C corporation, a Class C corporation. An S corporation stipulates that the income of the corporation will be taxed directly to the shareholders rather than the corporation itself. That's an important distinction. So the income of an S corporation gets paid in dividends that goes directly to, essentially, the stockholders. That's the best way to remember it. And that's where the taxation occurs. Rather than a C corporation, which makes money, the C corporation makes its money and gets taxed, then it pays out the money to its stockholders as dividends, and they get well. An LLC, limited liability company, this type of business model is neither a partnership or corporation, but takes the best of both worlds. Owners are called members, and rather than having articles of incorporation, this type of business has articles of organization. That would be important. The LLC is managed either by its members or managers, people designated by the members to manage the business. Different terms for different things. Members of an LLC are not liable for the contractual or tort liabilities of the business. So we have a lot of similarities of the corporation. We have a lack of liability that we would see in a partnership. Remember, the partnerships are usually responsible only for contractual or tort liabilities, okay? Joint venture, sometimes called a joint enterprise. I cover this because it's an important definition. This is more of a business relationship than it ever is a type of ownership. It's in which two or more people or companies or partnerships, so basically whoever, combine themselves for a single undertaking. It differs from a partnership in that it only has one undertaking and comes to an end at the completion of the task. So with a joint venture, and I would love to see this, this would be, one of the most epic disasters ever. Apple and Samsung decide to go into a joint venture and create a smartphone. It's going to be called the Galaxy iPhone. Okay? As soon as they create the Galaxy iPhone, their joint venture ends and the lawsuits begin, right? So fact of the matter is the joint venture is basically a task-oriented item. It is not really a type of business. You're not going to have a joint venture to quote-unquote make money. That's the underlying goal. And a franchise is an arrangement in which the owner of a trademark, trade name, copyright, whatever, licenses other people under special conditions or limitations to use those items in purveying goods and or services. So, franchises. Here in the United States, we are no stranger to franchises. You can't walk outside without finding a franchise. So a McDonald's or a Subway or a Burger King or a Taco Bell. There is a main parent corporation which controls the trademarks and logos. It controls the menu, copyrights, everything. Then you pay money so that you can utilize those in those supply chains while other people are taking advantage of the name brand of the corporation. So it's kind of a no-brainer. If you drive up to a McDonald's, you know the type of food you're going to get. You know the type of things you're going to order. So there are benefits to franchises. However, there's not a lot of local variety, which leads to disadvantages of a franchise. And we're going to save those for other classes where they go into this much more in depth. A franchiser, okay, is the individual that grants permission to use the property, and the franchisee is the person who receives the ability to utilize it. Usually these are considered independent contractors rather than employees. And we're going to see why that might make a difference when we look at agency coming up. Folks, thank you for your attention. We'll see you at the next lecture.